Sure.
Where we can start however you'd like to proceed.
Yeah, let's get started. I'll work on the camera while you're while we're doing introductions. So I guess I have the pleasure of welcoming everyone and to our presentation today. This is going to be a fact-filled session that we've got some the heavy hitters of this topic in the room. There's people on this panel that are on my short list of people that I call when I have problems. As you know, as anybody that knows me knows that I'm always happy to help people with questions and things. But these are my gurus and the people that I go to for questions and answers about some of these topics. So we have Ximena Calle from CGP&H, Vice President there. I'm so pleased to put the words Ximena Calle and Vice President together in the same sentence. That is fantastic. She's been in the trenches of affordable housing for a very, very long time. I know she would probably cringe if I mentioned the number of years. Speaking of people that have been in this world for a long time, Ed Schmierer, a partner with Mason, Griffin, and Pierson, also the president of the AHP-NJ board. Again, a fantastic resource and one of the most knowledgeable people on this topic, as well as affordable housing in general. And I'm also pleased to present today that we have Paula Sollami Covello, the Mercer County Clerk, with us today, and she's got a couple of her crew. I see Liz Pagino and someone else in the room to if questions get super technical.
Hi, my name's Noelia Segura.
Excellent. Thank you so much for being with us today.
Thank you for having us. Yeah.
I think this is going to be a little bit of a free-form panel, if I'm not mistaken. I think we're going to kind of bounce around, and I don't think there's going to be necessarily set presentations from each of the presenters. I think they got together on a call recently and came up with a format that is going to be very conversational and with some slides. There should be some opportunity for questions at the end. I think there's going to be 3 pop-up questions that you're going to need to answer if you are interested in obtaining continuing education credits. And I think that's it for housekeeping. I see Ed nodding. He's the expert on all this. So I'm going to turn it over to the panelists and let's get started.
Thank you, Mark. I think we're going to start with all of the wonderful ladies that joined us today. And I know Paula, who is the clerk here in Mercer County, has a lot of things cooking today. So we thank you very much for joining us initially, and also for your colleagues participating in the program. And the lady that really has the most experience in dealing with the day-to-day nuts and bolts issues about recording, posting, and discharging affordability controls is our friend who is going to be our first speaker today and kick us off with an outline. And Ximena, why don't you take it away?
Sure, thank you, Ed. Let me just share my screen and get this started. Thank you, Mark, for the introduction. As he said, I am been working in the affordable housing for over 18 years. I started with affordable housing. I want to say I grew up with affordable housing. We are here to see how do we record certain documents. And I did prepare a short presentation to go over, kind of give us an order of what the documents need to be recorded. As we all know, the documentation that we use for what we do, it comes from the UHAC manual, and we have all the appendixes. This is taken directly from the website, from the state website. So hold on, let me just share that. The state website gives us all the documentations that we require in order to either close on a property or have rental units under the deed restriction. I have made a little breakdown of the documents that we actually use on the daily basis. And they are these ones that I have here. Let me start with the Appendix C1. This is for regular new units, is done for condominiums. Ed, do you want to add a little bit regarding this Appendix C1?
Well, this is, of course, one of the critical documents that all of you in the world of affordable housing have to make sure is recorded in the local Mercer or the local county clerk's office. These set forth the restrictive covenants for new units. They can be for condominiums under C1, or it can be a deed for a regular single family affordable housing unit. But the key is to include in the restrictive covenant, in the recital in the deed, language that comes out of UHAG that underscores the restrictions on the property. And some of the most significant restrictions, which I'm sure are explained to every buyer or renter before they get involved with an affordable housing unit, is that the property has to be your own principal residence. You can't be purchasing these pups and then renting them out to somebody. Although as administrative agents, and I think we have a number of them on this Zoom today, you're going to find that some will try to do that. But the restrictive covenants really drive home and should be reviewed at the closing with the purchaser or the renter to make sure that they understand that you're getting a break on your rental charges. You're getting a break on what you're paying for the unit. But in exchange, you're agreeing to live there as your primary unit, and you're basically recertifying that you're income eligible to live there. So when you get to the initial documentation in this Appendix C, it's really critical that the AAs make sure that this is at the closing or is at the signing of the lease, so that there are no mistakes going forward what the rules of the game are.
So the other documentation that we also have to record are the actual deeds. The deeds are what we see every day on a transaction that when properties are ready to close. We have different types of deeds. We have what they call the Appendix A, Appendix B. The Appendix A was used for 95 units. That was before round 3. Appendix B is what we currently use right now. But what we need with this deed, so let me get you a sample of the deed that I have. We're looking at this deed. I love this deed because it actually makes life easier. As I said, I've been doing this for a while. At the beginning was, we're going to put controls. I don't know what's going to happen with my future. I don't know if I'm going to see this file again. And as long as I've been working here, I'm going back to the properties I closed a while back. So having the controls on the documents, which is item I, makes every admin agent's life easy. Is there, is recorded, dates are there. And I think this is the most important part that I like about these documents. The deed is, as you know, is between the buyer and the seller, and the controls is going to be for 30 years. It says a little bit of what the property is, how this is done. It is signed at the closing, and the party that is in charge to record these documents is the title company. I think that's what the majority of us have encountered a little issues with title companies. We check that the title has the fees on the closing documents. We follow up with the title company when we haven't received paperwork. But it is really up to the title company to send to the county for recording. That's about the deeds. Anybody wants to add anything regarding this?
Ximena, I have a quick question for you, or maybe a clarification. Could you go back to the deed screen? There's a passage in there that I see filled out incorrectly, and I just wanted to underscore the highlighted text, actually.
Oh, the highlighted text.
Yeah, so this is what we're attempting to fill out here is the control period for the unit. And I've seen a lot of people on a resale of a unit use the closing date as the starting date, which isn't correct here, right? We're supposed to be using the initial closing date on the unit as the start of the affordability control.
That is correct, yes. It's the initial year. Like if the property was first sold from the developer to the first owner and it was 1999, that's the year that it goes there.
Now, let me mention a caveat to that. Two things, actually. Number one, there are a lot of municipalities in their ordinances when a unit turns over, that is a sales unit turns over, will extend the deed controls, and they'll start them all over again. They'll push them out another 30 years. And so if that's what your local ordinance provides for, and you're the administrative agent, you have to be guided by that. And as far as I know, all the compliance plans that we've had approved following the 2015 declaratory judgment stuff, none of the courts have complained about extending these controls. And also really is key that the restriction is not just 30 years. You got to put in front of that at least 30 years. Very key, very important notation to make in your deed, because the deed will remain controlled, the unit will remain controlled as long as the municipality doesn't release it. And we've had some litigation here in Princeton with Avalon Bay and a few others about that language, about at least 30 years. And the appellate division has upheld that language. And that's what appears in UHAG, actually. So just be on the alert for when you fill that out, or when you're sitting in a closing or reviewing documents before there is a sale or resale of an affordable unit. Make sure it says at least 30 years. And if you have a shot at extending those deed controls under your local ordinance, I suggest you take advantage of that.
Thank you, Ed. Moving on. We also have, besides the deed, we have the mortgages that needs to go for county for recording. After the deed, this is the most important document you should have on your file. Without the recorded mortgage, you have no controls. Anyone can change a deed, but not anyone can get a mortgage out of the records. So I don't know how to say it and address it. We have to make sure that we get this recorded deed on our files. I have seen a lot of issues regarding what the title company does. Sometimes some title companies will record the affordable housing mortgage with the bank mortgage. If the bank discharges the mortgage, we are out of luck. We have no controls on the property, and the homeowner can sell it to whoever they want. If you haven't seen the deed, follow up with the county, see if the title company has sent the documents for recording. The most important part about this is our recommendation is to have at least a couple of original signature documents. If the mortgage gets lost anywhere by the title company in mailing, carrying it out, or receiving back to your office, you have another document that can start the process with the county again. It is very difficult to get the homeowner back to sign the documents after the closing. They have moved on, they are happy with their home. So it will save you a lot of time if you get to sign a couple of original documents at the closing table and being able to get this on your tips when you need it. We also have the Appendix Q, that's another affordable housing mortgage, is in base of the favor of the agency. In the years that I have been doing this, I have not seen a municipality doing in favor of the agency. They take the responsibility for the mortgage, but I thought I should bring it up too. The other document that gets also recorded is the Affordability Assistance Program mortgage. This document is also important because if the municipality is giving down payment assistance to a homeowner who's purchasing a home, they want to make sure that depending on what their conditions are for the assistance program, some of them are going to be forgiven for a certain period of time. Other ones are going to be discharged at the resale. Other ones will go down a certain percentage every year for a certain amount of years. So that's how the municipality will get any money back or no money back, but they just want to ensure that the money is secure on this mortgage.
As Ximena had indicated, the recording of the mortgage really is the second step, or as important as the first step, is getting the deed recorded with the deed restrictions. And I think the scheme set up under UHAG and before that COA was to make sure that restrictions on the property were basically recorded in two different locations. One is in the deed book that Paula and her colleagues manage and maintain, and that's where the deed gets recorded. There's another book called a mortgage book, and that's where the repayment mortgage gets recorded. So as Ximena says, anybody can mess around with the deed, and you may not know about it by trying to sell the property to somebody else who may not be income eligible. But you can't mess around with a recorded mortgage, because when the buyer's title company runs a search, it's going to turn up. And somebody's going to say, whoa, what is this affordable repayment mortgage all about? And that's a second way to really make sure that you're controlling the affordable unit. So that really the two key elements for the control would be the deed with all the restrictions in there, and then this repayment mortgage, so that you have it recorded in two different places and it will not slip through the cracks. I had an interesting experience recently. We closed on an affordable housing unit here in Princeton, and it was one that was owned by Princeton being sold to another income eligible household. And the repayment mortgage was executed and was about to be sent in by a title company from North Jersey who normally didn't practice down here. And they were refusing to send in the repayment mortgage for recording because it didn't have any figures in it, any numbers in it. And we had to go back to them and point out under UHAG that the whole purpose of the repayment mortgage is to guarantee eventually, if there is a unrestricted sale at the end of controls, then the property would be sold according to the UHAG regulations. You don't need a number. You don't need a number in the mortgage in order to get it recorded. And I believe they went ahead and recorded. And I think our colleagues down at the county accepted it because they always have. And then we'll get that recorded mortgage back. So that does get recorded, and it doesn't have to have figures in there. It's just an additional means of protection to make sure that the affordability controls are flagged on this particular title. And so you should be able to get that recorded. You also will get this recorded, the repayment mortgage, usually in the second position on the title. In other words, most of your folks buying affordable housing units, like the rest of us, have to do so after borrowing money from a bank or a mortgage company. And they are giving, you give them a mortgage, which they record to guarantee you're going to repay the money. That's a first purchase money mortgage, and that goes first on the recording. And then the affordability mortgage, or if there's an assistance mortgage or any other mortgage going back to the municipality, that goes second on title. And because that's the only way the lender would lend the money is if they're in the first position. So when the package goes in, and this is something most title companies know about, but if not, you can say they sometimes at the closing, they'll say to you, if they're not familiar with the repayment mortgage, and if you're there as the AA representing either the town or the seller, they'll say to you, well, is there any order for these to be recorded? And you should be prepared to respond to say, sure, the first purchase money mortgage gets recorded first, and then the repayment mortgage gets recorded in a second position on the title.
And the affordability assistance mortgage gets the third position.
Right.
Yes. So I just want to go back to the deed one time, because I was forgetting about the documentation that we need to attach to the actual deed. The deed that comes, we have 4 pages that we will check what the conditions are, but then it comes the affidavit of consideration that this is filled by the attorney who's selling the home. Ed can talk about this affidavit of consideration as he does it on his office.
Sure. Well, these are standard documents that Paula and her colleagues always look for when a document is sent in for recording. The first thing, and I don't think we have one to light up, but most of the counties now have cover sheets. There's a
I have
sheet
one.
with a bunch of boxes on it. That's the first thing that goes on top of your deed. And it used to be in the old days that the county clerk's office would go through each page of the deed and they would stamp it at the bottom, you know, page 29, page 30, page 31, and so on. Not any longer. On the new forms that are required just for regular real estate transactions, you have to have this cover sheet, which talks about who the buyer is, the seller is, the lot and the block in the town, and then up in the right-hand corner is the recording information. So that's the first thing that you have to remember. And again, the title companies do this routinely, or the real estate attorneys, if they're working on the sale, do this routinely. But if you're at a closing and you have the deed about to be executed, the first thing you ought to see on the top of it is Paula's box with all the little check marks in there that you have to complete. If you don't complete that, it gets bounced. And Liz or somebody will send you a nice little note and say, you guys screwed up and you didn't fill this out, or we didn't have that. And the deed will come back to either the title company or come back to the buyer and say, you got to get this straightened out. And as Ximena indicated, after the closing, it's a little tough tracking down sometimes sellers because they pack up and move to Florida or someplace other than New Jersey. And if you got to track them down and get something signed all over again, it's a real royal pain in the butt. So the documents that we have posted on the left of my screen is the seller's residency certification. So you got to check the appropriate box there to indicate your status. You write down the property address, who is selling the property, the date of the closing, and then there are a series of like 1 through 12 boxes that you fill in. So that 1 through 16 boxes that you fill in, and the applicable box would get filled in. In this case, we're using an illustration of a deed that we're going to use actually tomorrow, where Princeton owns an affordable housing unit, and they are reselling that unit to an income eligible household. So we have checked off the box to say that Princeton is a subdivision of the state of New Jersey, and then that would exempt us from having to pay the realty transfer fee because it is a instrumentality of the state, and there's a law that says that we don't have to pay for that. If this was a private deal, if there's just somebody who owned it and they're selling it to somebody else, and you're helping facilitate that, that box would not be checked off, and the section would be the seller is not an individual estate, a trust, or required to make any estimated gross income tax payment. That's usually for a traditional real estate sale, you would be checking that part off. And then the affidavit of consideration, that's usually important in the context of a sale where the realty transfer fee is actually owed, because the county clerk is responsible for collecting what's called the realty transfer tax. And that's based upon the consideration paid for the property. In this case, since we're transferring this as a municipality, I believe we checked off number 4, full exemption. And then there's a little A8B, by an instrumentality of the state of New Jersey. So this is a sale by a municipal corporation to an income eligible household. So we don't have to be sending Paula and her colleagues any money other than the recording fees, which you have to send, but you don't have to pay the realty transfer tax. So these are documents that historically and traditionally have to go along with the deed, whether it's an affordable housing deed or a market rate deed, it doesn't matter. And if any of those documents are missing, again, Liz will send you a note to say, well, you didn't turn in the certificate of residency and so on. And then you have to complete that. And then you got to get it back to them, along with her little nasty note on there to say, send this back too, so I know what to do with it. but
Oh,
that's-
she's not nasty.
it's
She's
not a nasty note. She's not a nasty note. We've got a swell operation here in Mercer County, believe me. And I hope everybody else from northern New Jersey and elsewhere has the same professionalism that Paula and her colleagues have
Oh,
down
I
in Mercer
appreciate
County.
that. Thank you.
But
Thank you.
they're absolutely dynamite to work with. But anyway, so those are the instruments that go along with the deed. As an AA, you probably don't have to mess around with that too much because a lawyer should know this, the title company will know it. And if they don't, the clerk will tell them that they should know it. And you just want to be familiar with those documents if you go to the closing table and somebody asks a question or you see these documents being going through. But they're all important in order to get the deed recorded. Ximena?
That is correct, Ed. As an admin agent, I don't fill out any of the last two documents. I let the attorney deal with those. The cover page, I will let the title company deal with that too. They know they are doing this on their sleep, morning, afternoon, evening, and they will attach what they need to attach. It does come for us when we don't have a title company. What do we do? This is not what normally we do, right? So my recommendation is check the county's website where you want to record the document. The county website will give you a sample, as Liz was showing on her screen, of the cover page. You can download that cover page, fill
Sure.
it out. And the majority of counties that I have had to call them and said, okay, I have this. Do I have all the boxes checked, like Ed was saying? They are very nice and they are able to respond to your inquiries. So check with them and they will help you so you can get the document recorded and not sent back for whatever you missed. I think it's time for the first question.
While we wait for that, Steve had a question in the chat about the practical difference between extending controls and refusal to release a unit from controls.
How to extend the controls. I can talk about that. The refusal, I'm going to direct to Ed. Extending the controls, it really depends. We have different ways of how the controls are going to be extended. Some municipalities are going to issue a municipal resolution. They extend the controls for everybody. So at the resale of that specific unit, the controls are going to be extended. Other municipalities are working with the homeowners and offer an incentive to extend the controls. They will give them a certain amount of money, and if they agree, they will get that money and the controls will be extended, not at the resale, but at the time that the owner is getting this money. And we have the other properties that the controls have expired, and we will talk to the seller and said, you have this opportunity, why don't you allow to have somebody else the opportunity to have this? The majority of homeowners have agreed. We do have a handful that they decided to sell the regular market. But we try to have those controls extended for almost every single unit that we have, to help the next person that is coming behind.
And I mean, the extension of controls for the municipalities for whom a lot of you as AAs work is tremendously important. And I say that because, believe it or not, we're coming up to the fourth round of the COA obligations in 2025. We're sitting here now, we're almost to the middle of 2022. So a lot of the towns we work with are beginning to dust off their old approved plan, see how they're doing with the number of units that they need to provide, and then beginning to scratch their head about going forward about how do we do this all over again for 2025 to 2035, which is really the next cycle and the next round. So if you as the AAs can entice or persuade some of your current occupants to sign an extension of controls, those extensions and those additional years that this unit will be affordable will count towards the municipality's fourth round obligation. And a lot of towns, because the numbers for towns are pretty wacko and very difficult to address under the current methodology that was approved by the courts, Judge Jacobson here in Mercer County several years ago. So the numbers for most communities are pretty substantial. So if you can, as the AA, start to bank some of these units, which are getting older and maybe coming up for, the 30-year mark or the, soon, and you can offer them an incentive. And I've seen a lot of towns will offer maybe a $10,000 payment so that people can upgrade their heating system, their air conditioning system, their hot water heater. And oftentimes, the older occupants of these units are very comfortable in where they live. They're happy to be paying a taxes on their property, which are significantly less than the fair market taxes because it's based upon, the purchase price and the restrictions on the unit. And you'd be surprised that a number of them, when you say to them, we can give you from our Affordable Housing Trust Fund a check for $10,000 or $15,000, if you would be willing to sign a new deed, which would extend the controls on your unit for 30 more years from the time we sign the new deed, or the time that the old period of control would expire anyway. And that really locks in that unit. It would lock in the unit for the fourth round, and it would get your municipalities early credits so that when you sit down to start the bidding for the fourth round and figure out what you have to do and what your number is going to be, you come to the table with a number of units that have already been quote unquote extended. And our experience has been you're going to get credits for those if they've been voluntarily extended or pushed out. So that's a very good heads up from Ximena about being proactive as AAs and coming up with a system to talk to people about voluntarily extending. And you'd be surprised a number of people will say, sure, I could use the $10,000 or $15,000 now, and I plan to stay here as long as I can stay here. And so where do I sign? And that's a real good thing for the folks you work for. Ximena?
Yeah, I think that's particularly useful too in with the Affordable Housing New Jersey, because there's not a big incentive for people to invest in their properties, given that the maximum restricted sale price is set by formula. So there tends to be some deferred maintenance, and rather than go out of pocket to replace the kitchen cabinets or that heater, it's that check is going to be super welcome. I think it's a lot more powerful than people can think. So we got the poll results from our first question. It was about the note, the affordability note. And we got some divergent answers, and I'm hoping the panelists can go in. I hope you could still see the results and maybe clarify this.
Yes, yeah. So the mortgage note does not get recorded, but it's an important document. Why? Because on the note, you have the conditions of the mortgage. And either affordable housing, it will tell you when it's going to be discharged. If there is an amount of money, if you're doing an affordability assistance, it tells you how that money is going to be paid back and when it's going to be paid back or when it's going to be forgiven. All those terms are in the note. So even though it doesn't get recorded, you should keep it in a safe place in your file. Like, it's the only document that it will tell you how that money is going to be paid back. So the note does not get recorded, but it is an important document.
And then I think we should probably point out that there are two separate documents. One is called the mortgage. That's what gets recorded. And the other is called the mortgage note, which Ximena just explained to you is an original document that should go back to the administrative agent and then coupled up with the recorded mortgage after that comes back from the clerk's office. But so the question was a little bit tricky in that we asked about the note, but the note is really not recorded, but the mortgage goes along with the note. The mortgage, as we said earlier, gets recorded, and you, the AA, and the town should get the original note. If you go to the closing, you ought to take that with you and then marry that up with the original recorded mortgage for future reference.
Did we answer the question, Mark? I thought it was a question from the panelist.
No, I think I think you answered, you clarified that
Okay.
question for sure.
Okay.
There's a couple other comments in the chat, but I'll probably just collect them up and save them as we get closer.
Okay. Moving on, let's just talk about the rental units. We have deed restrictions recorded for rental units. This is a big rental project. Developer is coming in to the municipality and they have projects. That deed restriction is recorded between the developer and the municipality, where they have an agreement how many affordable units they have. They are going to be having in that specific township. There are different forms that it depends the situation where the developer is at. We also have the Appendix E3, which is the deed restriction for rehab projects. This is where the municipality will rehabilitate condominiums, and then those condominiums will become rental units after the rehab is completed.
We should mention that these are restrictions that go on at the beginning. In other words, when the rental complex is created, you don't record individual unit leases. They don't get recorded, but it's really once they build something in your town, usually the first step is when they get their approvals for their new complex from the planning board, there's usually what's called a developer's agreement. And in the developer's agreement, it says that you shall be responsible for, and the standard rule is 15% for rental units. 15% of the units in the complex must be rented to folks who are very low or moderate income. And they're supposed to be dispersed throughout the complex. You don't just put them all in one building and with a sign on them say, here are the poor people. You don't do that. You have to work it into the overall development of the property. And then after you get the developer's agreement approved by the town council or the township committee or whoever is responsible for entering into that agreement with the developer, then we look for the restrictions to be recorded. And that's how, if anybody was to buy this complex going forward, they would know that they have an affordable housing obligation.
We do have a short list of other documents that need to be recorded. We discussed the housing rehabilitation mortgage. We have a discharge of mortgage. The UHA gives you an Appendix F for a quitclaim deed when the controls are no longer in existence. And you also have to use a discharge of mortgage when the property sold from owner A to owner B. Owner A, the mortgage for the controls have to be discharged, and you will issue the discharge, and then the new owner will record the mortgage of the property they are purchasing.
That's a good heads up about the discharge. I can't tell you how many times when an affordable unit is turning over, in other words, it's being sold again, that we will do a title search and you will find an old affordability mortgage still on record. And that obviously has no applicability because it's usually an owner or two prior to the one you're working on. So then you have to go about getting that mortgage discharged, which is a simple one-sheet piece of paper, and you send it in to Paula and her colleagues and it gets recorded. But that's the only legal way to remove that from the title. So it's important that a discharge of mortgage for the leaving seller gets done. And then you put in the new mortgage for the new buyer, which takes the place basically of the old mortgage. But I'd say about half of the units we see and the title reports, maybe not half, maybe a quarter of them still have this old lingering affordability mortgage on Schedule B when you have to address those before you can go forward and put a new mortgage on it. So don't forget to remind whoever's doing this or to make sure that there is a discharge of mortgage.
And the
Great.
last comment I wanted to say was the subordination agreements. Subordination agreements are not recorded in the county clerk, but the lender does need this in order to issue a refinance.
I'd love to jump in with like a quick scenario that I see a lot of times in communities and get some feedback from the panelists. And Paula, I'd love to hear your comments on this. There's on the topic of discharging things, and typically this relates to the rehabilitation loans that are provided. Sometimes this also relates to subordination agreements. There are, I see a lot of times that there are transactions in process that are time sensitive, and these things pop up, or these things need to be done by a municipality. And sometimes the municipal process for executing these documents is a little cumbersome. I've seen situations where council, a resolution is necessary in front of council in order to discharge and postpone. I'm wondering, is there best practices? Is there a way in which a town could set up a person that could be able to sign off on these documents and sort of help these transactions happen more quickly? Because sometimes there's interest rates at stake, and even real estate transactions at stake in the case of a rehab loan that goes back 10 or 15 years, and that person's trying to now sell the property.
I'm going to let Liz and Noelia speak to this, but I think you're asking us about municipal, how they're operating. And I know some towns are more successful at it than others, but I will let them, they may have better, more efficient offices, but I'm going to let them speak to this. Do we have anything to add?
Yeah, Paula, tell us which are the good ones. And no, don't tell us. Don't you dare. Well, it's interesting, Mark.
Liz, did you want to add something, Liz?
Go ahead, Liz.
No, go on. I was just wanting to know, so what you're saying is if we can get them processed faster, is that what you mean?
Not so much on the county side. Sometimes there's these cumbersome processes at the municipal level to get the document executed. That they've set up internally that this can only be done by council. And that's a 6-week affair, in some situations,
right,
depending on how the meetings fall. That could be the difference maker on a real estate transaction or a refinancing.
Understand. Well, that's something that we can definitely discuss and talk about on how we can help you figure that out to get that done faster.
But like it's really a municipal issue.
Yeah,
so
right.
that's more on a municipal level. Yeah.
Yeah, Mark is correct, and Liz and Paul are correct. The process locally can be cumbersome, particularly during the summertime when a lot of these towns go to one meeting a month. And if you have to do a resolution and get the mayor and the clerk to be able to sign, et cetera, it could really slow everything down. However, I think a lot of the administrative agents are not aware that under the UHAG regulations, under this NJAC 580-26.14 A17, it says the administrative agents, in other words, you don't have to go to the town to do this, the administrative agent can ensure that the removal of the deed restrictions and the cancellation of the mortgage note are effectuated and properly filed with the appropriate county register of deeds. So if you have that authority under the local ordinance, which appoints you as the administrative agent, and most towns have affordable housing ordinances, and in the ordinance, they copy this UHAG regulation for what are the duties of an administrative agent. And oftentimes, I found that the administrative agent may not be aware of their ability to be able to sign a discharge of mortgage, and you don't have to go to the town. A lot of other municipal ordinances delegate a lot of this stuff to the administrative agent. And so this is kind of a routine thing. If an old mortgage turns up and it never got discharged, it's not a policy call. It's a matter of law that it needs to be discharged. So let's appoint somebody to do it, and we appoint the administrative agent to do it. But for the other stuff, you're right, Mark is correct. If, for example, in Princeton, if we own a unit that the housing board recommends we sell to an income qualified household, the housing board has a meeting. They make a recommendation to the council, and then the council adopts a resolution authorizing the sale, or if we're buying the unit, authorizing the purchase. So it does become pretty cumbersome. But I think, you guys down in Mercer County, though, are extremely cooperative and helpful. And maybe if we run into that stuff over, particularly the summer months when everybody's not meeting that often, and it's nothing that can be done administratively, maybe we could come up with plan A about how we would be able to address that and move things along. Because Mark is right, you can lose, particularly in this mortgage market with rates going through the freaking roof, almost as high as the gasoline.
Right.
You could lose a mortgage commitment, and the lenders, when things are down in the 3.5%, 4% range, we're not kicking too much about extending mortgage commitments right now. If you get a mortgage commitment and you don't close in the 45 days, good luck, because they'll say, well, we'll stick with you, but the new rate now is 5.5%. And here's an affordable person or any person who's trying to buy, and their original rate was 3.75. The differential in that monthly payment is remarkable. So we really do have to make sure that things move along and are facilitated.
Unfortunately, now we're talking about like the law and the legislature and getting them involved in changing things, because I'm sure that the municipalities, they want to have a say in who is paying less taxes and paying less, and it all ties together. What's an affordable unit? So, that's why it's cumbersome. And you're right, Ed, we can work with you, of course. We'll work with you as much as we can to make this work and work smoothly. But we're dealing with these laws that are set for reasons that are beyond our control. But yeah, absolutely. That you can always work with us, and we're happy to work with all of you. And I know the other county clerks as well. I work with them closely. And if you contact them in other counties, I am sure that they will try to assist you as well as best they can. Even if it's just for us to make a phone call to the municipality on the behalf of the attorney or the lending company, we can do that.
Good, thank you.
I think right now we have questions for the Mercer County, unless anybody else has any other questions that we can respond.
Before we start, I just wanted to say a few words, if that's okay, before we ask the question.
Absolutely.
I just want to let you know that most of the county clerk's offices in New Jersey, we've all reopened, and our search rooms are reopened, which means you can come in now and you can search for documents. And also we have our office in Mercer County. We have 2 websites that are public information sites. If you want to go on and search for property information, you can do that by going on our New Vision System website. And Liz can tell you more about that. That's something where she actually signs you up. But you can go online to Mercer County Clerk, mercercounty.org.
Yes.
Click on my county clerk website, and you'll see a link there in order to sign up, and then they'll sign you up to be able to search the New Vision system. We also have a unique system in Mercer County that is not in any other county. It's called the Property Information Portal. It's unique in that our county has combined with our engineering department, our planning office, our tax office, so that you can go onto this property information portal and you can get information on a property, not just to look at it from the property standpoint, but also to see the tax information, all these other pieces of information about that property, restrictions, things of that nature. The property information portal was public, and now it is no longer public because of Daniel's Law, which somebody asked me to talk about a little bit. But I will say that Daniel's Law has put in an exception for professional real estate companies. We have a questionnaire on the portal. If you meet the criteria, you can then get back into it. And also, you should probably know that with regard to the PIP, I'll give you the email address for that. It's pip@mercercounty.org. So if you go on there and then you sign up and you pass the criteria that you are a bona fide real estate professional, you will be able to get back into it. I'm not going to talk too much more about Daniel's Law at this time, because I will tell you that the entire state is not sure how to handle it. All of the counties are dealing with it. What happened is that, unfortunately, a young man was tragically murdered. He was the son of a federal judge. The legislature put in a law that stated that as a result of this, no one can share information about police officers, prosecutors, judges, and now it'll be soon elected officials, which means that their property information had to be wiped off the books. It's creating a very difficult time for property searchers and land title associations, because now they're having to deal with the fact that people have vanished from the records and the chain of title. And we are working with the Land Title Association of New Jersey to figure out, and the state of New Jersey, how exactly to handle this, because obviously it creates a difficulty for searchers and title companies. But I think that this exception with the bona fide real estate professionals will help a bit so that they can view them. But at the present time, we are still waiting for state guidance. And the state has advised us that in July of 2022, we're going to have some guidance on Daniel's lawsuit that will have more information. Unfortunately, we really don't have it all at this time. And lastly, I wanted to say that you can buy a New Jersey Recorder's Manual from the Union County Clerk's office. If you go on to ucnj.org and you click on Document Reference Manual, you can get it printed, bound, or on a CD-ROM. And it has all the statutes regarding all of the information that we've been talking about. So you can reference that. It's a phenomenal tool for a recorder. We use it in our office. We have it and we share it. And it's just something that I recommend that if you do this for a living, it's a good thing to have. So you have to purchase it, but the money goes to a scholarship foundation, and it's helpful to all. And last thing, now let me just make sure you know that my two staff members are two supervisors in the office. This is Liz Pagano is the supervisor of the recording division, and Noelia Segura is the supervisor of the indexing division, which is the office that verifies the properties and assigns the book and page to it and scans it in. So they work very closely together on all of these items and can answer many of your questions and are a great resource to us and a great asset to the office. So that's you are. So I want to let you guys know that they're here for questions, and I'm going to now turn it back to them and to answer questions that you might have. All right, thank you.
Thank you.
Thank you.
Thank you, Paula.
Probably one of the things that you could cover for us is how the state's set up. Your mileage is going to vary when you go from one county's document portal to another, and I'm wondering if you could talk a little bit about that.
I guess that's me. When you say every county has different, we all have to follow the state statutes with regard to recording, every county. And we have different websites. This is kind of a general question, that's why I'm taking it. We have different websites, and we all navigate them differently, but we all have to follow the same rules with regard to recording properties. That's something that we all do.
Yeah, I've noticed though that there's obviously the back end of these repositories are different based on the different interfaces that you see when you log on to them. And I was on one recently where you couldn't put in an address. You could only search by the name of the grantor or the grantee in the database. And yours is, the counties, I could go block and lot, I could go street, I could go names. It's much more robust. And is there? I always, every time I run across this, I always hope that there's some movement afoot to standardize all of this and get it all the same.
We all have different vendors that run our land records management system. Mercer shares the same system with many counties, but we don't all share the same. We have New Vision systems. I think I can't name them all, but Middlesex uses it. Camden uses it. Many counties do use New Vision systems, and they have a very easy system to work with. And we also use Sunrise systems for our e-recording portal, and we share that with 11 counties. And that's so if you learn it in one place, you can use it elsewhere. However, we can't mandate statewide that everybody use the same vendor. So that's all we really can say about that.
Understood.
Paula, and I was maybe kick this over to Liz and Nicole, but one of the wonderful features Mercer County has is that you can go online and get, I guess what you stamp on there is an unofficial copy of an instrument. And all the clerks don't do that, but Mercer County does that. And that becomes important, I think, for the AAs as a starting point. In other words, if somebody comes in and they say, can you help me sell my affordable housing unit? And the AA says, well, okay, fine, but our records are terrible. And the municipal records are terrible. Can you tell us, when did you buy your unit? Have a copy of your deed. And most of them will say, no, I don't keep that kind of stuff. And the first thing we do, or you can do if you're in Mercer County, because of you, Liz and Nicole, is to get an unofficial copy immediately of the deed. And then you know exactly when it was purchased and what the purchase price was. And then the AAs can work from there. So you guys are state of the art in terms of Mercer County. Whoever's on this thing who's not in Mercer County, you ought to freaking move, because they really are good down here and easy to work with. But Liz, are there any other things you can get unofficial copies of? I know we get deeds, but can we get mortgages and other things?
Absolutely. You can get copies of almost all our documents that are available to the public.
Mhm.
And you put that big stripe on there, unofficial, right? So that everybody knows
that
that
goes
it's not
through
a
our-
sealed. Yeah.
Yes,
Right.
yes. Or you can come into our office and you can always request a copy of your documents. And that's any document. That's deed, mortgage, discharge, cancellation. If it's recorded, we can give you a copy of it, as long as it's been verified and able to be seen to the public.
Yeah, that's
And
a
we
wonderful
also-
service you folks have.
Yeah,
Thank
and
you.
we do also give certified copies here as well. So people who do lose their deeds and stuff like that, like you were talking about, when they come in here, we do have the option that we do give them a certified copy, so that way they can, it's basically, it makes it more, I guess you could say, official. Yeah. So they can obtain that. So we do have all different various types of, copies that we can give here. So it's a good service that we have for that.
I've had a couple of calls from affordable owners responding to a scam that goes on. And you can hear it on the radio, where somebody will say, unless you enroll with us for $99.99 and get a copy of your deed, somebody could sell the property out from underneath you. And I've had at least a couple of phone calls over the past year or so asking, should I do that? And you guys run into that at all?
Yeah,
All the time.
all the time, all the time.
Yeah.
Yeah,
That's
a lot of
actually-
people, a lot of people are actually, they call very concerned, especially,
That's where the property alert comes in.
right, exactly. So, yeah, there are people with that concern. A lot.
I wanted to, we put press out about this from time to time, letting people know that you don't need to have a certified copy of your deed, and certainly you can get it from the county clerk's office for less money than you would to have this middleman go and pay them like an exorbitant cost for something that's a government service. Because I think our fee is like $10 a page for certified, and these people are charging you basically like a huge fee to be a middleman, and they're making, if they prey upon seniors with that, seniors and people who might not speak English well, or someone who doesn't know, and then they purchase these things, and it's really unfortunate, because we have to provide it. If a company comes in and asks for it and pays, we have to provide it to them, and we know these people are being like ripped off.
Ripped off,
unfortunately.
yeah.
But
Well, you're on top of it. Yeah.
Thank you. Liz, you mentioned the property alert system, which we have a property alert system as well. So if somebody tries to record a deed on your property, or a lien or something onto your property, we have an email that goes to you, the property owner, if you want to sign up for that, unless you know someone attempted to record a lien or restriction on a property, and you'll get an automatic notification of that. We recommend everyone do that.
Are you aware of any other counties that have that set up?
Most of us that have New Vision have signed up to also have that.
That's fantastic.
And yeah.
Speaking of the public records, there's a question among the bunch that we've got to cover before the end. There was a question in here. It was a comment really from Loretta Rivers, that I heard that information on public record cannot be found on county websites anymore. I suspect she's talking about Daniel's Law.
Yes.
Yeah, unfortunately, until something comes up from the state, people who are involved with Daniel's Law, such as the police officers, like Paula has stated, unfortunately, we had to block their data and their image from public record. However, as like Paula said before, as soon as the state comes up with a way for us to get this situated, then I'm sure things would pan out and run a little bit smoother in that way. A lot of questions are being asked that there's really no answer to right now, or anything we can give you on that aspect. As of right now, anybody that's situated or has to do with Daniel's Law, unfortunately, we cannot give anybody access to their files or their records.
Right. Yeah, because that's what the law is right now. So we're waiting for further clarification.
Yeah.
At least now, like with regard to the fact that bona fide real estate professionals will be able to have access, that's a big plus and something positive for all of you. But at the present time, we're still waiting, as she said. So we have to block them. Now, and that's why some counties took them off altogether. Some counties took down their search systems. We did not do that. We just blocked out the officials that needed to be blocked out. But yes, some counties took them down because they just didn't know how to deal with this law. So it's made it a bit more inconvenient.
Right.
Paula, could you mention again, how do you sign up for that email alert?
That's on our website. You can just go onto the mercercounty.org and click on County Clerk, and it'll say sign up for property alert, and you can just sign up.
Okay, thanks.
But if you want, did you want to ask them about rejection reasons? Because I think Noelia and Liz are ready to talk about some of the reasons for rejections. I just wanted to I know that.
Yes, thank you.
I mean, I don't want to change the subject, but I know that was something.
No, that's actually pretty good. Ladies, why don't you tell us why a document gets rejected?
Okay, so one of our biggest reasons is the acknowledgements. The acknowledgements aren't done correctly. We do have to follow a statute about acknowledgements. We're covered under Title 46, so we do have to follow that. So there's a lot of acknowledgements that come in that unfortunately we have to kick back for several reasons. Easy reasons that can be resolved right away, but unfortunately that's a big one. Do you agree?
Yeah, I would have to say the biggest reason that I see being in the indexing section is I see a lot of acknowledgements that come in where people are signing off on behalf of a company and they are leaving out their title, and they're also leaving out as well the company name. So basically it's just making it look like, yes, even though John Doe signed off for, Sunrise Bank, John Doe's only signing off. So it looks like basically it's John Doe who's in charge of everything, but it's really John Doe is the vice president of Sunrise Bank, and he is the one who is authorized to sign on behalf of that. So we do run into a lot of arguments because they always say, well, the name is on there, but it's not you on a personal level. It's you signing off on behalf of a company. So I do see that mistake a lot. And I do, I would say really mostly that's like kind of the biggest one that I do see is just the acknowledgement and not having the title and the company name in it. I have to say that's a big one.
Another reason for rejection that we have is when you file a deed, we don't accept PO boxes. We need a physical address. That's a big one.
Yeah, that's very big.
We also, the municipality. Municipalities, there's some municipalities that Mercer County has a name for that maybe Atlantic County or I don't know, a different county might have the same. So it'll come in Hamilton Township, County of Atlanta, like Atlantic, stuff like that. There, Cranberry is not necessarily in Mercer County, stuff along the lines of that. We also get cover sheets. Cover sheets are a big deal with us to have to be sent back. We like everything to match the document. However, the cover sheets came out so that way it would be easier for us to index off of the cover sheet instead of the document. Personally, it's not easier for us. However, we do have to follow the statute and the law. So we have to have everything in sync with the document. Everything has, from the cover sheet, has to match the document. And that's for indexing purposes for down the road, later on down the road, because as you know, that cover sheet now becomes, at this point, now becomes the first page of your official document, because that always has to travel with your document throughout its course. So that's a big thing for us.
So there's an interesting question in chat about the prepared by line. It says on the deed, are there legal ramifications for the administrative agent to be on the prepared by line, and is the prepared by line required?
So we do need a prepared by. It doesn't necessarily have to be on the front page of the deed. It can be somewhere throughout the deed. It doesn't have to have, like before, in the good old days, it doesn't have to have prepared by Liz Pagano and then my signature underneath. It can be typed, it can be written, but it does have to be somewhere on the deed. It no longer has to be on that first page like it used to be. I hope that answered.
That's excellent.
A little.
There's also a question in the chat that's in the Q&A that says, I know of a title company. I know a lot of title companies were recording online during COVID. How do you know, how does a company know when their documents are being recorded because the title company is handling the documentation? Can the company be CC'd on the recording documents? So
that's our e-file system, which has become very, very, very popular since COVID. When you submit a document, you can either submit it as a title company. There's third-party agents that you can go through. So once you submit your document either as a title company or an attorney, you'll get, once it's recorded and verified through the e-file system, you'll get your information right back. As far as the third-party submitters go, I can only speak on our end for that. I don't know how they get the information back to the client or the company that submitted it to them to submit to us.
Liz, can you explain a little bit what the e-system is? Like, how is this a program that is paid? Can anyone pay for this and you will have access to all the records? Can you go into that a little bit?
Are you speaking about our e-file system? Or
yes, the e-file system.
Oh yeah, it's free, and it's operated by Sunrise Systems, but it's on our website and you can sign up to be an e-recorder, and we prefer it. It's fast, it's easy, and you can make sure the information is correct. We don't actually record. You kind of put everything in, you fill in the fields, and then you send it to us and we accept it. And we also accept payment that way electronically. So it's been, as Liz said, it's increased incredibly over COVID, but we've got a lot of people e-recording now, banks, mortgage companies, title companies. It's just, and it's used by 11 counties besides Mercer. So you can talk about this more, but I wanted to give you the overview.
Oh, no, that is great. While the Daniel law was going on, we were thinking how we can get a copy of the recorded document, because that's what we're based as admin agents. We need a copy of a recorded document in our files. And one of the ideas came up, what about if we record the documents that we can record instead of having the title company record these documents, because sometimes we don't even see them. So thank you for the information. It's good to see a way around.
We accept recordings from anyone. It doesn't have to necessarily just be a title company or an attorney. You can have your aunt bring in your deed to have it recorded, as long as it's in recordable form and meets all the statutes that we need it to meet to be able to be recorded, and your fees and your transfer tax and all that are what they should be, then we can go ahead and record your document.
So if we miss anything on this e-recording that we're doing ourselves, how is the rejection sent?
It's sent back through the e-file queue back to you
Okay.
instantly.
Whoever's assigned to putting it on, basically they will put in the reason that they are rejecting it, and then they'll reject the document, and the document will go back to the submitter, whomever that might be.
Instantly.
Yeah.
Thank you. Thank you for the
Mhm.
information.
There's a really interesting question in chat, and I think there's maybe multiple panelists are going to have to hop on this one, but it's the question is, can the panel discuss the process of discharging rental deed restrictions since units may not all expire at the same time?
Okay. They want to know how we discharge them on the county aspect? Is that?
Well, there's certainly a documentation step, before it gets to the county with
Right.
how to sort of parse out the unit that's being discharged from what is probably a blanket document that's discharging multiple documents. Ed, do you have any thoughts or suggestions on this?
Well, number one, I would be shocked that municipalities are not using, and there's a similar language in deeds as there are in the master deeds for rental complexes, and that is the property is restricted for 15% affordable for at least 30 years or until released by the municipality. I haven't heard of municipalities releasing those restrictions. And as pointed out, Ximena mentioned earlier, a number of municipalities have adopted blanket resolutions which says, good luck, you guys are signed up forever. We're never releasing these restrictions. So if you have a complex that's coming up to 30 years, and there could be, I mean, affordable housing has been knocking around now for a while. You should really carefully take a look at the ability to get those 15% units released and whether or not the town has to approve that. And I would be shocked to see if they could go through that process and bingo, just have them released. But it would have to be done at the local level first. And then there would have to be some sort of a release put together, sent down to Paula and her colleagues.
I have another question. So the recording fees.
Okay.
Admin agents that do a lot of documentation for a municipality.
Okay.
If we send it as a company, the recording fees are going to be the regular as any other person. How can we find a middle ground that if it's something for the municipality, the county will give the lower fees? Like, what do we need to do?
Okay, so the municipality has to send us a letter on the letterhead granting permission to you as the authority handling their document to be able to be charged the municipal rate. We just need to have something from them stating that you are who you are and that they are authorizing you to conduct business for them.
And do we need to attach that letter to every document we send
No.
it, or it's just
Nope,
one
just
time
need
and then?
one letter, all my recorders get it, and we know what to do at that point from there.
Okay. Thank you.
And that's a real good heads up for everybody on the program, because as you know, I mean, the recording fees generally have skyrocketed over the last 5 years. I mean, it costs you, $340 to get a mortgage recorded. Well, they're sometimes 20 pages long. But if you can take an affordable unit and get the municipal rate for the recording, you're saving your trust fund money, and you're saving your town, and you're saving the buyer really a ton of money. So thank you. That's a real good heads up. If you learn nothing else from this freaking webinar, you learn that, and it's going to save you a lot of money. So write that down.
We also have accounts that can be opened. A municipal level can open an account with us. Anybody can open an account with us. So you would just send in, when you send in your documents to be recorded, you're just going to tell us, we'll assign you your account number. We would have to need, of course, if you wanted to do that, letterhead with your company on it, who your contact person is, an email, a phone number. It's depending on the kind of account that you want to open, whether it's just for copies or recording fees. There is a minimal fee that you have to, open your account with. However, once you do that, we assign you your account number. So every time you send in your documents on your cover sheet or your cover paper, when you send them in, just say, please charge my account for my account, I don't know, 27 for my deed and my mortgage. We'll take it right from there. You can always check your account balance. We actually have this great thing that we just got, that you can go online and punch in your PIN number that we give you, and it tells you your account balance and when you have to replenish, when to replenish your account, or how you feel about that. That's very helpful to us in the recording section. So that way we don't, people aren't going into the rears, or I can't record your deed because you don't have enough money in your account to cover your recording costs. Stuff like that happens, but that's a really great tool that we have, that we like to push out to everybody and let them know. Of course, you can always call and ask or send an email. We're always okay with helping and answering any questions that you have.
And just to jump back, piggyback on what Ed said, that yes, it is phenomenal that you can, get the municipal rate, but it's because statutorily the municipalities have this ability to have a discounted rate. So you just can't write in, hey, I want the municipal rate. I mean, you have to actually be doing work on behalf of a municipality to qualify for the municipal discount. So I just want to point that out.
Paul, it's probably safe to say that each county may have a different level of documentation required to establish that connection for the community. Someone asked in chat whether or not there was like a resolution to name them as the administrative agent would suffice as this, paper trail. But it's all this is handled separately, right?
We don't really require that, but we, if we were to ask for proof, I mean, yeah, because the municipality does every year pass a resolution appointing their attorneys, appointing people to do work. So we can if we wanted to get verification, I'm sure we could, but we don't usually require that, right, Liz?
No.
We don't, no.
Just that letter with the, stating from the municipality that you're giving Noelia permission to file your deed, to work on your behalf. That's all we need, just so we have something to show in case we're ever asked.
Paula, on the municipal rate, if a municipality was using one title company for most of the purchases of, affordable units that they then resell, could the municipality send you a letter and authorize the title company to get that rate?
Not that I'm aware of.
No.
No.
So it'd have to come through the AA or somebody who's associated directly with the municipality.
Yes.
Okay.
I imagine the challenge would be that title companies, even for that closing, is going to have things that need to be recorded at the retail rate. Even if they are recording something on behalf of a municipality. So now you got this package of documents that have multiple rates, and I can see how that might be a challenge.
Yeah.
We've got about 9 minutes now, and we've got a bunch of questions in chat. So we're gonna play rapid fire here for a few of them. And, we'll start at the top here. Someone asked about how property taxes are handled for restricted units. Clearly not perfectly in the agenda for here today, but I think we've got enough people here that can jump on that and provide a real quick answer.
Well, property taxes for affordable units are based upon their quote unquote fair market value. In other words, they have a restriction on there, just like if you had a piece of property with a big environmental restriction on it. So they're usually lower. There's a case which was decided about 15 years ago to say that the assessor has to take into consideration the controls and the inability to resell that at market. So for the most part, at least in my experience, has been that you usually get taxed at about a quarter or a third of what you would get taxed at if you were at market.
Thank you. For deed restrictions that do not have a specific expiration date, but rather say the controls are in place for at least 30 years, the municipality would not need to provide monetary incentives to extend. Is that correct?
Well, you don't have to provide them. I know we have some very persuasive AAs around the state who get in touch with these folks and persuade them that it's a good thing to do. So you don't have to offer, those, but you can point out to them that if you still want to receive, like the earlier question, the reduced reduced assessment on your property, and if you continue, you will, then a lot of folks will bite. But there's no requirement to make any payment to them in order to get them to extend.
On that topic, there's another question. It says, our deeds have a statement in them that says 30 years unless extended by municipal resolution. Branchburg just did this for one of our developments. That's a perfectly acceptable way to describe the controls, correct?
Well, it is, but if you want to be safe, I would put at least 30 years on there. I mean, there's a case that has been decided that says that at least is very important. So if you want to cover all bases, I would just put that little at least 30 years or until released by the municipality.
Okay. Gail offered up a comment that about notarizing. I guess we were talking about affordability. We were talking about notes at that point and how helpful that is. Steve had a question about the developers agreements and whether or not they should be, whether or not they include income levels and bedroom distributions. I think we've done I think we have a checklist on that from a prior presentation, but if anybody wants to.
We do. Mary Beth Lonergan put together a beautiful checklist, but most of the time in the developer's agreement, it really just says you got to comply with UHAG, Uniform Housing Affordability Controls. It's all in there. But the better practice is to dump it into the developer's agreement so that somebody could find it.
Yeah, Denise threw the citation in about the administrative agents. Thank you, Denise, having the ability to discharge and release. Yeah, Corinne had a couple of comments about the rehab notes and discharging them in particular and some of the challenges that they've had. Let's see. There's another question here. I think this is our final one for the day. Yeah, Steve Weinberg is a Mac user, and he's not a big fan of the limitations of the New Vision system, not allowing Mac. My suggestion,
it's actually improved. They've made improvements, so it's a lot easier to use now for Mac users. When we first started it, they were not too compatible, but now they are.
Yeah, I remember issues with Internet Explorer as well. Like it was only Internet Explorer. I could not use Chrome or Firefox or anything. But yeah, I'm happy to jump through those hoops for as powerful as that system is. So no issues here. Steve, you should be good from here on out.
Are you still experiencing problems? Because I was told that it was all upgraded and working great now.
Yeah, Steve, let us know if you have any other experience on that. Yeah, Corinne mentioned that Ocean County requires an authorization letter for each recording request on behalf of a municipality. So that's a further example of how your mileage may vary on some of the comments that we're hearing from the Mercer County Clerk and how things may be handled slightly differently from county to county. So the result of that last question, let's say 82% of you said no. The title company for an affordable purchase, does the title company for an affordable purchase prepare the repayment mortgage?
Yes, title company do not prepare the repayment mortgage. That's done by the admin agent.
Very good. Yeah, the phrase "at least" in an agreement does seem a little disingenuous, Roger. I think most of us agree, but best practices and that case that Ed was mentioning rule the day here. Someone asked earlier on, we had a anonymous question. Is there a standard formula for repayment that must be used, or is that up to the municipality? And I guess we're talking about affordability assistance, rehab, and other types of monetary?
Well, my experience is they all vary. I mean, sometimes if you get a rehab loan, it may be forgiven on a yearly basis up to 10 years. So, and they may cap it at $30,000. So you might qualify, you sign a note and a mortgage. And then if you sell in year 2, then you would have to repay some of that amount. And most of them are without interest. That's been my experience. They make the loans without interest. But each municipality is different. Some give them grants. I mean, some just give you the money, but most of them don't. Most of the towns will want to get the money recycled back into their trust fund. But you really have to read and see what the local affordable ordinance says and how that gets handled.
And is it your experience that the forgiveness of loans or the awarding of a grant is a income tax implication on behalf of the homeowner?
I've never asked the question. I don't know. I don't think so. I mean, you know, a lot of our folks who are in the affordable housing don't even file income tax returns. So I don't think they have to worry about it.
Yeah, that's a good question. Good point. Yeah, I think we covered. There was one question from Alexander McLean. I think I know the answer to this one. He's asking if you're a developer, a named redeveloper, can you get the municipal rate when recording with the county? I know.
Good try.
Nice try, but I'm gonna save Paula and her team the trouble. For recapture mortgage, the formula is appraised value less the affordable price. For the recapture mortgage, oh yeah, that seems
It's the
reasonable.
round 3 documents.
All right. Well, I think we got about a minute to wrap up. I'm glad we got through all the questions. If there are any other questions that people think about later, certainly email them into HPNJ. We'll circulate them among the panel and see if we can get an answer back to you. I believe slides will be made available after the presentation. A recording of this is being made and it'll be available on the website if you think of anybody that may need to you know, sit in on this or may find it interesting. Please do. Please check out the HPNJ website and keep an eye on emails that hit your inbox from HPNJ for future programming. I know there's at least a couple of new sessions in the works. Ed, am I missing anything as far as a wrap up goes?
No, we'd encourage you, if you're not a member of AHG&Pay, you ought to become one because we do these things regularly. Lindsay will keep you informed and hopefully you find them helpful. And Paula and team, thank you very much for taking the time today. It's swell seeing you again. We look forward to seeing you in person.
Absolutely.
for having us.
Thank you for having us.
And just
I
a quick
believe
shout out
a
to the
brief survey will pop up on people's screens when I end the presentation. So if you'll take the survey to give us your feedback, that would be appreciated.
Thank you. And a very quick shout out to the program committee for putting this together and organizing this all. You guys did a great job with this one. Thank you.
Thank you.
Thank you, everybody.
Thank you.
Thank you.
Bye-bye.
Bye.